eligibility, licensing strategies, and balancing IP with public health and societal needs. Let's kick off this session by introducing our moderator, Mr. Muhammad Yawar Irfan Khan from United Trademark and Patent Services, UAE. With over 20 years of experience in IP law across South Asia, the Gulf, and MENA, he is a senior member of his firm and an active participant in international IP conferences and committees. Joining him, we have an exceptional lineup of speakers. First, let me introduce Mr. Dipak Mundra from Sumitomo Chemical India Ltd. With over 20 years of experience, he specializes in patent and trademark law, IP litigation and strategy. Currently serving as Vice President of Intellectual Property, he blends legal, scientific and managerial expertise to lead successfully. Next, we have Ms. Jaya Pandeya from Lakshmikumaran Sridharan Attorneys. With over 15 years of expertise, she is a seasoned professional in drafting and prosecuting patent applications in software, electronics and communication. Her strategic approach and deep knowledge of EPO patent practices make her a trusted advisor. Joining us next is Mr. Sparsh Arora from Lear Corporation India. As the intellectual property leader, he manages the full patent lifecycle, supports strategic IP transactions, and enhances R&D efficiency across diverse engineering domains, ensuring global impact. Now, let's welcome Mr. Abhishek Bharti from GE Aerospace. A legal expert with a stellar career, he has advised on compliance, litigation, and regulatory matters at the United Nations, TICO, and GE. With degrees from NLSIU, Bangalore, and Fletcher School, USA, he is also an accomplished author. Lastly, we welcome Ms. Manisha Bhagwadeen-Duraswamy from ENS Africa. A trademark specialist and a fellow of the South African Institute of Intellectual Property Law, she delivers comprehensive portfolio management across various industries. We will now begin.
Thank you very much. Good afternoon. I hope the session is vibrant because you have all had lunch and no sleepy attendees. This is what we learned from the law school and the business school. So I'm very honored and privileged to chair this session with a galaxy of speakers around over there, and I will not take enough of your time. I would spark out opening with Mr. Dipak to give his talk and the experience about the main topic we have. Thank you very much.
Hi, good afternoon everyone. My name is Dipak Mundra. Welcome to all of you to this session. This is a very general topic that we're discussing about the IP laws and the challenges in obtaining IP or enforcement in IP in different jurisdictions. My other co-colleagues will throw more light on that. I will talk mostly about the general, just to give a warm-up sessions to what the points that we are going to take up. I would appreciate that since this is a subject which most of us are very familiar with, if there could be more of an interaction, questions, sharing of experiences, that would be helpful to enrich this particular session. If I talk about the conflicts and all of that, I'll start with by saying that what are the challenges in obtaining an IP in different jurisdictions. Now, one thing that we all know is there is a lack of harmony in the IP laws of different countries. Primarily, if you see, like in India, and if I compare with US, US may allow you method of treatment, it may allow you software patents. India has its own restrictions in terms of allowing such patents. Those software patents are allowed, but then with modification that we all know, they have to enable with hardware and all of that. Method of treatments are not allowed. Same is there in Europe. So there is a lack of harmony in terms of the laws. There are some specific laws which different countries follow. Like for example, if I put in, US does allow terminal disclaimers. India doesn't allow terminal disclaimer. We saw one recent judgment in India of Delhi High Court, which was the Dipak judgment, where terminal disclaimer, which AstraZeneca had used in US, how it was exploited in India to say that because you had used terminal disclaimer US, so therefore it would be considered as a case of agreeing to the fact that it was obvious there. Now, US is a very specific country having its own specific laws. Using a terminal disclaimer in US and applying that in India, see how it resulted in. So these lack of harmony of IP laws in different countries have its own challenges. Your patent term adjustment in other countries like in US, in Europe as in SPC, we do not have in India. You have negative disclaimers which are allowed in some jurisdictions, VIP prosecutors, we know that Japan allows negative disclaimers. India doesn't allow, US doesn't allow unless there is support in the specification. So there are various things. One important thing which we all remember is anticipation and obviousness while we prosecute application. The law of obviousness itself is a little different in what it is seen in Europe and in US. In Europe it is the teaching suggestion motivation. After the KSR case which was decided in the US, the law became much more holistic. That is, a person of skill in the art was given much more importance, general knowledge was given much more importance, reasonable expectation of success was given much more importance. So basically, if I can put it, the law of obviousness was the bar was slightly lower there. For example, in Europe, if the teaching is there in the prior art, and if it's showing some technical advancement, it would be considered as an invention. Or inventive step would be a law which would be allowed, but in US, if there is a common general knowledge associated with that, teaching suggestion motivation is not the only law that they follow. So there are challenges, the harmony is not there, but then possibly in due course of time, all of these challenges will be overcome. One challenge that I think so most of us, we who prosecute applications, we know is the challenge of translation of documents. And translation costs lots of money. If you prosecute in Latin American countries or any other countries, there's huge translation cost for us to engage in. I remember the amount of spending which used to be in translation always used to be questioned. And I tried my best to reduce the translation cost by engaging some independent translators. And then I realized that it had its tremendous amount of challenges. Like, I'll give an example. How important is the word comprising in our patent law? If it gets changed to consisting of, what happens? It becomes open-ended to close-ended. Let's take an example. For example, you have a lubricating oil in your claim and changes to machine oil. A lot of challenge when you enforce that particular patent. Same with the change in the percentages or the concentration range and all of that. 0.01 changing to 10% or 1%. So translation always, I would suggest that when we are translating a document, we engage an attorney for that purpose. At least it should be vetted or reviewed by a patent attorney. So these are the challenges which I think are primarily outlined. All of you might have come across their own challenges. You can share your thoughts. This is about like how we get our applications or prosecute applications. The same set of challenges when we enforce our patents. Different countries have its own challenges. Now it comes from the developed, what's it, developing countries. Developed countries have developed their process of enforcement. Developing countries are still protecting the local industries. So in that case, you'll find that the challenges are of a different sort of. The enforcement agencies may not be trained, IP offices may not have sufficient funds with them. We in India now we find our patents are getting granted quite quickly, but at one point of time it used to take years, 5-6 years to secure a grant of a patent. Brazil still takes a lot of time. There are other challenges like damages. India has now moved towards more of this area where damages are granted, large damages are granted, but some countries damages are not granted, and that doesn't act as a deterrent for them at all for IP infringement issues. So there are issues in terms of patent enforcement, which different countries play out, but then I think so with the jurisprudence being developed, the country being having more of IP culture over there, that should also be taken care of. And so the rest my discussion here. I would appreciate after we finish our discussion, please if you can share your thoughts, your challenges, and what would be suggestions you might have in terms of IP enforcement or IP securing our IP rights. That would be helpful to know. Thank you.
Thank you very much. I think it's a very nice start to the session. I would just make a comment that the epicenter of patent filing is really a volcanic eruption. I've been witnessing to the R&D sections of Honda, Toshiba, Samsung, Eli Lilly, Pfizer, how they file patents in 165 plus countries. So you can imagine the instructions going out and implemented the same day with the filing date. So we will come to that. I will now request Mr. Arora to highlight what his observations are.
Thank you so much, Yawar, and I think you've set the stage very correctly in terms of the challenges which are there and how particularly manufacturing companies are, thinking about their patent filing strategy and their protection strategy globally. So one thing which is kind of very much observable, which you would have seen, is this. If you see the last few years trend of filing in different countries, the growth of filing in certain countries kind of outlier. And the reason for that is multifold. One, we're moving towards an industry 4.0, which means there are a lot of GCCs setting up, like the global capability centers. You see, Bangalore is like every day there, you see Economic Times, you see a news of GCC setting up in Bangalore and these countries. Even not just in India, even outside India, like there are COEs developing up, which is Center of Excellence developing up. Particularly in the manufacturing side of things, companies are very strategically choosing where they need to do the R&D, where they need to do the testing, where they need to do the manufacturing and large scale commercialization. So the global patenting strategy is very rapidly changing based on how the industry is moving in this direction. Recently, we would have seen that a lot of companies, especially post-COVID, earlier a lot of manufacturing was happening in China. Now a lot of the local entrants are coming in. Manufacturing is getting shifted into Mexico, and then like West Coast countries, where they get the maximum value out of it. That is driving a lot of change in how the IP is getting protected in those specific countries. Now this is the business side of it. But it's very, you have to take a very comprehensive strategic decision in terms of, rather than just going for a unidirectional approach of filing patents in only those countries where you have the market. That's no more the case. It's multi-directional now. You need to figure out which are the areas where you need to follow a defensive approach of protecting your know-how, whereas which are the areas where you can potentially file patents and do your IP protection in terms of the offensive approach, and that is highly driven by the laws of those countries and the ecosystem of those countries. As Dipak was mentioning, that what is the enforcement time in that, what is the litigation timeline in that country, how are the damages getting calculated. You have countries wherein you have a bifurcate court system, wherein you have the infringement proceedings in one court, whereas the invalidation proceedings in a different court, which gives a lot of leeway to certain players in terms of the enforcement. So thinking like in terms of IP strategy, it has to be definitely backed by the business strategy, which means your commercialization strategy. It has to be backed by the IP strategy in general based on what the current ecosystem is, and it has to be backed by something which is like a moving variable, which is unknown. So when we imagine it in terms of like 165 countries, we filing patent, think of it like a Rubik cube, which is 3D cube, where you have one face of it. You have countries in all of those such blocks. Every block represents a country, and then you have IP strategy as one facet of it, which would dictate that what is the ecosystem in that country. You have the business strategy as the second side of it, which would dictate that what is my market over here, what is my competition's market over here, what are the strategies that other players are following in that direction, and then you have a third facet of it, which is the unknown, which is the moving variable, which is like whatever changes would happen in a short-lived span of time. So it has to be a very comprehensive framework to dictate and decide how companies are going to file the patents, going to protect, and what would be their global IP strategy in terms of the protection. So I think I'll just take a pause here, and then I'll pass over to my colleague Jaya, who can specifically talk about the specifics of each country and what should be the specific things that we should take care of when moving to different jurisdictions. Thank you, everyone. If you have any thoughts, we're happy to discuss afterwards also.
Clock is taking right in front of us.
Yeah, clock is right in front of us.
We're running ahead of time.
I will save some time. I'll be
We're running
going.
ahead of time.
Okay. So my day-to-day job is to draft patent applications. So I draft patent specifications in the area of telecom, software, electronics and related technologies. And the applications we draft, they are filed maybe sometimes directly with the USPTO, EPO, PCT applications, of course. So what we see is for major applicants to now be aware of at least the major requirements of the jurisdictions of their interest. If you're drafting a patent specification, you don't want to end up in a situation where at the time of filing with the USPTO, you're doing some modification to your specification. Then with the EPO again, you're doing some modification to comply with their jurisdictional requirements. Like you said, Dipak, there are differences in laws, right? And you want to comply with all these jurisdictional requirements, which are not uniform, right? And specifically in your claim and your enablement requirement, you want to be complying with all jurisdictions, right? So one thing that I've seen with a lot of applicants do is to have a jurisdiction-specific guidelines for themselves. Earlier, it was just the big major applicants who had these jurisdiction-specific guidelines. But now I see mid-size applicants as well have this sort of a checklist for themselves, because then they know, okay, these are the major points that I need to tick mark and say, okay, I'm complying with it, so that I'm able to effectively prosecute the application 2 years down the line. So what are the major things that they should bear in mind maybe? One, Dipak, you talked about the eligibility criteria being different. So if you're drafting, say, a software-related application, you have to comply with a stricter requirement of technical effect of EPO, but at the same time want to leverage the broader scope that USPTO would give you. So you sort of draw your balance there. Then is it a method of treatment? Is there mention relating to atomic energy, which could be excluded subject matter in some jurisdictions? So you have to take care of all your eligibility requirements when you're doing the drafting. Other thing, I believe, Dipak, you covered this too. The inventive step assessment criteria being different in different jurisdictions, right? Europe is very specific about having the problem solution approach. So they will look at the closure start, and there has to be an objective technical problem. And this problem, the claimed invention has to be a solution, non-obvious solution to that problem. It's always very, very good to have in your specification a discussion of that technical problem solution. The art will be obviously identified later, but unless you have the discussion of technical problem solution, your prosecution before the EPO is going to be difficult. Right? And other than these substantive things, taking care of eligibility requirement, taking care of inventive step assessment, certain other things are also important, and they could be maybe administrative or procedural based. For example, if you're going to file in Japan or China where translation is required, cost and time required to translate is one criteria we talked about. But other than that, at the time when you're doing your drafting, you need to take care of things like consistency in terminology. Because if that's lacking, then of course, every time you translate into a different foreign language, this is going to present a whole set of different complications. And again, very simple things. US will allow you 20 claims with 3 independents, EP will allow you 15. Now we can say these are very minor chotu points, like let's ignore, but then applicants are becoming very, very cost sensitive. And we all know every small bit of extra claim free can add up to your budget, and cost management is such a big concern for applicants at this point in time. So these are the few things we can bear in mind when we are doing our drafting exercise for patent specification preparation.
I would just add one thing. When you are in the operation theater of the filing scenario, you have to look into a lot of aspects, because 165 countries are involved, and as she pointed out, we handle the global portfolios in the GCC region. The translation is a basic issue. You have to be technical so that later on the examiner doesn't object to any of the translated forms being objectionable. And as I said, there are teams divided into different aspects. I think when a big company, giant company from US is filing globally, they have divisions of team members handling. Not one person can handle 165 countries. I think they're divided into 10 or more teams. So the cost, of course, the cost is the lead aspect. And from the commercial point of view, every global corporation eyes his or her future earnings generated from the patent protection. That's the main lead thing.
So one point, to your point of having local expertise, working with say the GCC attorneys, when you're working with when you're filing your applications in GCC, what I have learned in my experience is, other than familiarizing yourself with the statute, with the law per se, what is also very important is to have awareness of the practices. every patent office, every set of controller examiners will have their own practices, and these practices sometimes can be very, very hard to fight. For example, in India, CRM claims are as such not prohibited. Act nowhere says you will not get a CRM claim. If the test is technical effect for a CRI and it exists in the system and in the method, and you're granting me the system claim and the method claim based on technical effect, the CRM also has that same technical effect and hence is eligible. But try getting a controller of the Indian Patent Office to grant you a CRM claim, you will not, right? And for every small instance, you will not have your applicant run to the court. That's not practical. So you need local guidance to be able to maneuver such practices. So I think it becomes valuable that you're working with someone who's aware of the local practices as well.
One good thing which has become, I think so you're right, that there are 4 patent offices, in fact 5 now, if I include the Ahmedabad one. The controllers have their own way of coming up with their own reasoning. Then if you argue that this case has been of the same precedent has been applied somewhere else, they'll say it's up to that controller, that patent office. So there is no uniformity. Harmonization is not there in our own patent office itself. But now with the IP division and IP codes, which I can put it, that is coming to India, as that part is to a large extent being taken care of. The decisions which are coming up, at least those are binding upon those controllers, so that the lack of harmonization which we had and which we still have to a large extent is being to a large extent addressed now. I think so many of you who are practicing, they would like to comment upon that.
Thanks, Mr. Khan. Thanks, Jaya. Hi, everybody. I'm Manisha from ENS in South Africa. I'm a trademark attorney. And I've joined the panel today to chat a bit about Africa, why invest in Africa, and particularly some filing strategies that I'd like to share with you all. So there's 54 countries in the African continent, as sure you all know, and we've got a population of around about 1.2 billion. That's estimated to double to around about 2.5 million by 2050. 11 of the world's fastest growing economies come from the African continent, and the continent is rich in natural resources, minerals, and oil and gas as well. So the question is where to invest in Africa, and the top 5 territories, as per our last research done towards the end of last year, indicates that it's the Seychelles, Mauritius, South Africa, Ghana, and Senegal. And I'll just briefly mention as to why. So Seychelles, the territory is highly reliant on tourism and fishery, and there's great opportunity for improvement in those areas of innovation and import concentration as well. So Mauritius, there's free trade agreements. It's really a destination where investors are seeking to invest, and many organizations look at it as an entry into sub-Saharan Africa. South Africa as well, there's a memorandum of agreement signed, which actually is in favor of investors, so to ensure that the processes are fair, efficient, and there's investor confidence as well. Ghana has a population of around about 33.5 million people. It's a substantial market on the African continent and marked as around one of the 10 territories in Africa for improvement, urbanization, employment, and innovation as well. And the last one is Senegal, which is part of West Africa. Very easy access to the international markets and the African regional continent as well. Those are the territories that you would generally look at in terms of where are you wanting, or where is your client wanting to invest in Africa. I'd like to speak a bit more of the practical aspects of filing strategies in Africa and how do these organizations and clients choose to enter the African continent. It's a large continent, there's several countries, and there's many strategic factors we take into account when we are actually advising client on this. So, we'd look at business activities of the client, where are they actually operating on the continent, or where do they intend to start operating, what are their future plans, what is competitor behavior like on the African continent, where does the organization fit in terms of those statistics. We also look at factors like first to file territories in Africa. So there are a number of territories where user rights are not recognized. First on the register means that they have the first right. Does become challenging when you do want to, get into that country, file a trademark, and you found that a third party has done so. We look, depending on products, we look at anti-counterfeiting hotspots on the continent, where we recommend that, make sure that your IP, your brands, trademarks are all protected. We also look at territories that are litigious, where it's very expensive to litigate, the laws are archaic, they have not been updated, and it's best to ensure that your IP is protected so that you're not involved in, quite costly litigation as well. So those are some of the factors that we would take into account when going through filing strategies. We'd also, there's 2 regional systems in Africa. I'm sure many of you are aware of it. It's called a REPO and OWAPI, OAPI. OWAPI is a single application that gives you coverage in a number of the West African countries, and it's automatic coverage. A REPO, it's a system where you can designate, so it's also a single application, but you can designate countries under the application. There are around about 15 member states that belong to a REPO, but we really only recommend that we designate about 5 of those territories, because those are the countries that have actually amended their laws and give effect to an REPO registration. On the patent side, there are a few more territories that can be designated under an REPO, but on the trademark side, we definitely don't recommend designating all the countries in order to seek protection. So that's just an overview of how we would approach, giving advice in the African market, just in terms of the different points and strategies we would look at. And yeah, if you have any questions, I'm most happy to take them or to meet you outside to chat a bit more about this. So thank you.
Hi. Thank you. Thanks, Mr. Khan. Thanks, panelists. So, I thought I'll just give it a different drift, because you've been just listening. So, and thanks, Manisha. It's a perfect segue for me, because I'm supposed to talk about some of the geopolitics and IP aspect. But let me ask you, do you see any IP interplay when it comes to current geopolitics? Say Russia-Ukraine war. Do you see any? It's up to the. I'm just throwing it out. Do you see? Okay, if I say export controls, sanctions, tariffs, do you see any interplay of IP over there? Because export controls, sanctions, tariff wars, this is all geopolitics, right? Do you see any interplay there?
No, I think IP is exempted to UN resolutions. So countries like Syria, Iran, Iraq, Yemen, you protect patents and trademarks over there freely. So maybe the financial implications are there. You cannot remit money there, and it's a real uphill task.
Right. But thanks, sir. So you will see some kind of interplay there still. And the interplay is basically, when it comes to sanctions and export controls, the first industry to get impacted is always a very IP heavy industry. Okay, say pharma, say aerospace, healthcare, renewable energy, semiconductors, etc. Right? So what I want to say is that IP is no more a domain of lawyers or technology experts, but it's going into economic sphere now. Okay, so it's expanding its sphere. So it's becoming more and more important now that we have an equitable access and distribution of intellectual property globally. So I'll just give you some examples. When you talk about geopolitics and IP, you see US had accused China of infringement of IP a lot of times, right? And they said that, and that initiated the tariff wars between the US and China. And then there were sanctions and some embargoes, tech embargoes, after Russia invaded or that war started. And there were sanctions on Russia and there were sanctions on Iran, which actually restricted the advanced technology and export controls of semiconductors, for example, and it just disrupted the supply chain all over the world. Then you have example of Huawei, and Huawei is, again sanctioned by the US, and it stalled its advancement into 5G innovation because of the sanctions. Then you have, my friend from South Africa, you would know how pharma patents have worked over the time for India and South Africa, because especially during COVID, what had happened, world thought that Western nations were holding patents and pharma patent rights, and there were not equitable access given to the entire world or benefit of that pharma patent regime. So India and South Africa actually led efforts to push for a temporary waiver of rights under TRIPS, and it worked. And it worked in such a way that now we have equitable global access to life-saving technologies globally available, right? So when we think of IP, and especially this session, IP launch strategies for the global market, we have to think beyond technology, beyond law, and think about economic choices also, which are being made right now in geopolitical scenario. So this is just a flavor I wanted to give. Kindly participate, my request, our request rather.
Thank you very much. We are running really ahead of time, so we'll have a lot of questions. Let me close and sum it like he is truly right. But regarding the IPR embargoes, I repeat that even the US Section 301 list does not prohibits any applicant to protect his or her rights in all these sanctioned countries. And special permissions are sought to remit out monies to these countries via intermediary banks and other sources. So we have 11 minutes. And what do you want to add?
No, I just wanted to add that IP has become a tool for diplomacy, as you rightly said, through the UN, etc. Right? And it's proving to be a very valid tool, because somehow geopolitics is weaponizing IP,
Yes.
which is happening, right?
So we will open the floor with the Bharti and Manisha, our colleague from KNS, and Rosh and Mr. Dipak. So it's all over. Please raise your hands if you have questions. We have 10 good minutes to take up these professionals so that they can answer you back. Please go ahead. No questions, lucky.
I have a question, but I can just add on to it. With respect to global marketing, global IP protection, for example, just a few things. One thing could be there are certain policies in every country. For example, in India, you can do custom recordals for IP. So while your products are entering the market from some other country, you can always have them, the trademark, for example, you can have that recorded with the custom office, and while the products are being transported to your country, the custom office will take care of certain infringement if that's happening at the border. Now, when it comes to global market, other thing that we can also see that, a lot of clients come to us and they always say that we want to globally capture the market, but they don't really know how to identify the countries that they want to capture. So as IP attorneys, we always suggest them that, these are the countries that you can capture as per the products and services that you're providing and offering. And, last but not the least, I would also say that we, as attorneys, we always work with attorneys across the border. So it's important for us to work with the local attorneys and, trust them and the process, so that the process becomes smoother and faster for us.
Thank you very much. I'll crack a joke here because you will feel that I used to train the custom officers. So one lady called me and said, "Sir, I have a genuine counterfeit consignment."
That was actually an excellent input, and I just wanted to add another point there, that we as Indian attorneys, when we assist our domestic applicants in IP procurement, sometimes we forget to think about other types of IPR rights that are not available in India, but they are outside. For example, maybe the German utility model, not the German utility model, rather the utility model which is available in Germany, Australia, and several other countries can be applicable to some applicants, and those are also some things we should explore.
I would like to just point out, as like you said, this TRIPS agreement is some agreement which rather provides guidelines to all the global jurisdictions who are part of the WTO to comply IP laws in accordance with the guidelines given in the TRIPS agreement. And as regards this IP management globally, as you rightly said that you draft an application for a specific jurisdiction, it is primarily to bar the competitors to copy it. At the same time, parallelly it can be considered you might have some business interest in specific jurisdictions. In many jurisdictions you might not have business interest. There, instead of barring, you are providing a product to them to follow that technology. Not barring others to copy it, instead providing this patent technology as a product to them. That is another way of monetizing your own IP. This is another aspect of them look at it.
I just wanted to go back to your comment and just to share, like in terms of Africa, so South Africa, we've also got a very thorough customs anti-counterfeiting system, very similar to what you've mentioned for India. Trademarks are basically marked or recorded with our South African revenue services, and also checked upon arrival into the country and detained and seized if there is suspicion of counterfeit goods, and it is quite a thorough process to actually get those goods declared counterfeit as well and then destroyed. And very similarly in Kenya as well, and some of the other African territories, they are, the law in Kenya is quite new, but it is quite an effective system to deal with counterfeit goods as well. And just to your comment about clients wanting to enter the global market, so Africa, as I mentioned, we deal with it very strategically. So yeah, reach out to me if you need any help on that, because we have various factors to take into account, because I know it can be really daunting looking at all these countries and not knowing where to start. So yeah, thanks.
See, we are all mostly from India, and we know the laws and practices in India. We have Mr. Khan with us. He has office in Karachi. We would be quite interested to know the practices in Karachi, the enforcement in Pakistan, whether IP can be enforced. Like India has moved a long way now since 2005, the TRIPS agreement, into product patent regime. In fact, in my previous organization, where we have licensed out a lot of patents and we earned a lot of royalties out of it. Indian courts are now become quite IP cognizant. They are granting damages, huge damages now. How is it in Pakistan? Like, do really IP has a real value there? Can it be enforced there? How IP courts looked at patent rights there? Please throw some light on that.
Yes, thank you very much. As I told the questionnaire, we have a custom recordation for the trademark owners. We do have the courts functioning very speedily, and it's a real good thing that they value the foreign owners of the IPR rights, and their rights are exercised and enforced across all over Pakistan. Irrespective that the politicians do get the relief, but the IP owners also get relief in Pakistan, as compared to the famous character who is now there. Our courts were loaded with work, so they have now established the IP tribunals in the major cities, Lahore, Karachi, Islamabad, and one more city is being added. Like, irrespective of any country's love or affection or hatred, the rights are exercised valuably and speedily. So enforcement, it depends on one owner, how he or she wants to take action against an infringer in Pakistan. We are our courts, as I say, we are very speedily understanding the global scenario, and having been, put on the warnings for several 301 violations by our good friends from the United States. We value the relationship to have IPs exercised completely because it is the economic tool of success. Because the owners, the investment and friendships, they don't exist if your IPs are copied. We have a larger investment from China, Japan, Korea, United States is our strategic partner, and then UK. So all their rights are, I'm very happy to say that, right from the lower court till the Supreme Court. They are very cautious of this fact.
If there is no other question. Adita is a patent litigator, so she'll let me
So just coming from that point of view, no question as such, but just when we are making submissions before the patent office, also sometimes becomes very important to get a litigator's point of view, especially in Form 27s. Where we've seen a lot of controversy around that in SEP litigation. You have the various statements that are being made when it comes to genus and species patents, when the prosecution happens, and especially when you apply for extensions, patent term extensions, statements being made. It's important to get a litigator's perspective as well at that point of time, because end of the day, when the patent enforcement is happening, we are the ones who have to defend the patent in court. So just when the statements are being made, especially when it comes to something which might tomorrow be litigated in court, it's important to get that perspective. That's the only input.
Adita, when you mean that patent extensions, are you referring to other jurisdictions?
Other jurisdictions. So India doesn't have it, but when you ask for it in the US, because US has a patent term extension and they have a genus patent which can be granted as well as species patent which can be granted. But when you make the statement as coverage and disclosure, because Indian law, because of the Novartis decision, there is a big statements, the kind of statements that we've been making in the US and EU, which are hitting now when it comes to the enforcement of species patents, especially. So we're a little careful. It's not that it's impossible. Just careful about the wordings that we put in the basic patent term extensions that we seek.
You were part of the dapagliflozin litigation. Just wanted to ask you about the terminal disclaimer which was there, which was taken in US. How do you read to that provision being exploited in India? Because that's a very specific provision to that particular country. If you are starting applying laws of US and India, naturally you can't apply Indian laws to US or any other jurisdiction. Every country is specific in terms of patent laws.
So that's
how do you read the terminal disclaimer aspect?
Terminal disclaimer is something like patents of addition in India. So therefore it becomes very important. Again, I come to back to it when we litigate it, when we come to say it's covered. Now covered is in India, as per the legislation in India, means what is disclosed in the patent application. If it's not disclosed, it's not covered, is where the courts are going. We're trying to argue and show that it's not exactly the same, because our coverage will never be equal to what is disclosed. So dapagliflozin is something that Mr. Anand was doing. I'm more in the other litigation, and exact terminology I'll not be able to help there. But it was a patent of addition is equivalent to kind of a patent of addition in India, rather than a species patent.
This is just like a regional patent in US. In India also regional patent. When you add something which is not there in the regional patent,
See, actually, sir,
add on something. Add on to that.
Actually, Adita, actually, it's not actually patent of addition. See, terminal disclaimer is something where you have an obviousness argument thrown at you, and you have a patent application which is cited, and the same applicant is same. What you do is you bargain with, I'm just putting it very literally, you bargain with the patent office that I'm going to let that patent to expire at the same time when the patent application expiring. So the cutoff days you agree to the same. Now it is like admitting to the fact that it's not a literal admission, but it's an admission that yes, the patent is obvious and therefore letting it expire at the same day. That's not how it is to be read, but that's how it was interpreted and read in Indian courts. And to an extent, the courts also believe that since you had agreed to an expiry date of the earlier patent, therefore you cannot have a patent which is expiring at a later date when the earlier patent has expired. So, but then see, the laws are specific. Therefore, I was saying there is no harmonization of IP laws. So once there is a harmonization of IP laws, these sort of issues can be tackled and taken care of.
So I'm warned by the organizers, we are running, time's up. So thank you very much, the participants and the attendees. We are grateful to your hearing to our speeches and our inputs. It was a wonderful session, widely and actively possible. Thank you very much.
Thank you to our esteemed panelists for their valuable insights. Now, may I request our moderator, Mr. Khan, to facilitate the speakers. We will start with Mr. Dipak. Next, we have Ms. Jaya. Mr. Sparsh. Mr. Abhishek. And Ms. Manisha.
I was about to joke that you marketed your phone set, so the commission should be given to the organizers. Excellent, thank you. You are a group order. Thank you. Thank you.